Stephen, in the meantime, I'd like to introduce you to Professor Dr. Ratan Singh, who is the director of UILS, and Professor Singh, Mr. Stephen Williams is the director of NTU Global, who's been leading the partnership with Punjab University.
Welcome, sir.
It's a great pleasure. So yeah, thank you for allowing me to join you. I guess this afternoon our time, evening your time, and it's great that Vasilios can be with us and give this talk today. So, so thank you again for the invite, and thank you also to Shruti for setting this up. It's fantastic.
I think it's a brilliant platform that we've been, during this lockdown, we've managed to get everyone together in what we couldn't achieve a few years ago. Dr. Vasilios was trying to, so if you remember last year, he was supposed to come and deliver the lecture and he could not make it because of the problem, the attack and the flights being diverted. But we finally have the NTU team with us. And it's
I suppose this is very good platform. At least everybody can join us now.
So I'll just we can start. I think people who are having problems, they can maybe join by and by. Meanwhile, we should start. So I'm going to introduce everyone, and then I will request Professor Ratan Singh and then Mr. Stephen Williams to share their thoughts and welcome the participants and the guests on this platform. Firstly, it's Stephen Williams, who is the director of Nottingham Trent University Global in the United Kingdom, who has been leading the program, the MOU between Punjab University and Nottingham Trent University, along with his team. Then we have Dr. Vasilios Adamides today, who will be speaking on populism, democracy, and rule of law in the time of COVID-19. He is the principal lecturer and the international manager at the Nottingham Law School of Nottingham Trent University in the UK. We have with us Vidhi Sahai, who is the Senior Global Partnership Manager of South Asia, Southeast Asia, Australia at NTU Global, UK. And we have with us Chris Cabot, College International Manager at NTU Global, UK. Professor Ratan Singh is the Director of the University Institute of Legal Studies, Punjab University, and it is under his guidance and leadership and supervision that we have managed to arrange for these kind of webinars and online sessions. I would request Professor Ratan Singh to welcome our guests and say a few words to them.
Thank you, Dr. Shruti. Really, this is a great honor for me also that I'm sharing some of my observations on this platform with my young friends. So first of all, on this platform, I welcome to Mr. Stephen Williams, who's the director of NTU Global, UK, and Dr. V. Adamides, who's the international manager, Nottingham Law School, UK. And I welcome to Vidhi Sahai and Mr. Chris Cabot on this platform for the deliberations over populism, democracy, and the rule of law during the time of this COVID. Really, the topic which Dr. Shruti, along with the team, has chosen up for deliberations, for the discussions. This is the need of the time to deliberate over this topic, because recently once we talk about populism, when we talk about the democracy, and then the rule of law, these are the three topics which are directly or indirectly, they are attached with each other. If I start from one thread and move to another part, then in between I have to start from populism and need to go to the democracy, and then we need to go to the rule of law. Because without populism, no democracy, and without rule of law, no democracy. And this is not something which we are talking with reference to only India. Probably if I see, the whole globe is facing the problem with the COVID-19. And the problems are like a social problem, medical problem, economic problem, and nowadays some way of the political problems. So reason being, when the great leaders of the respective countries are giving the statements regarding their economic policies or political policies, regarding their social measures which they are taking for the protection of the people. So how effective measures they are taking, how effectively they are protecting the people, how effectively they are protecting the health of the people, the health of the community, and how effectively they are correlating with the other nations of the world. So probably this is the nature of the government too also. Now, when we talk about the democracy, and certainly we always feel like to say like Abraham Lincoln, that we the people, the democracy is of the people, for the people, and by the people. Now, when we take about of the people, mean OF of the people, BY by the people, and FOR for the people. But someday, while giving a critical analysis in some of the countries, as the different political parties are doing, and I use the word instead of BY, I say BUY by the people. OF, I say not OF, this is OFF of the people. And I say not FOR, this is FAR for the people. Now, this is the shape which nowadays the democracy is taking up. Now, friends, as far as the rule of law is concerned, we understand the government is passing different policies, new legislations are coming up, new enactments are coming up, new ordinances are coming up, just only to solve this problem of COVID. It may be health issues, it may be issues regarding human rights, it may be issues regarding economy, it may be issues regarding other like for instance in education also. Hundreds and thousands legislations, policies, executive orders are coming up. Now, issue comes is whether these policy measurements, whether these legislations are really touching the stone of rule of law or not. Whether these are according to the principle which we have settled down, that the rules are to be done accordingly, according to this, or a reason being our parliamentarians or the legislators, they are under the stress, and in order to take very quick actions, today they are making a one law or one policy, and tomorrow immediately they are changing and they are taking another action. And on third day again, they are reverting back from their two actions which they have taken, and the third day they have taken a different action. This is something they are getting panic, or they are not getting another way for getting the redressals of these problems. So this is the problem with the rule of law in these days, that whether they are suo motu taking an action, whether one minister is taking an action or one administrative head is taking an action, and whether this is according to the canons of the populism or not, whether this is according to the democratic values or not. Because the democratic values are that these actions, these orders, these legislations are to be in the interest of the society, in the interest of the people, in the interest of the welfare of the subject matters. Now, talking over these three issues is probably require a long debate over this. And in the present era of COVID-19, we are suffering from an issues of human rights, issues of legislative policies, issues of health. Now, whether the legislative mechanism is of such a nature that we have to go ahead with this or not. So friends, this is a time for us to deliberate over all the things. And I hope our today's talk will definitely take us to some of the concluding remarks, so that we can think about the thread which we are living, and we can have thought-provoking ideas over which we can go back to our respective places and can conduct our further studies for our writing research papers, or maybe articles, or maybe any other research activities. So with these words, I welcome to all the panelists here, welcome to all my colleagues, my students, and friends from UK. Thank you very much, and back to Shruti.
Thank you so much, Professor Ratan Singh. It is indeed a pleasure to have everyone from NTU at this platform, and I would like to apologize for the inconvenience caused by this technical hiccup which we are experiencing today, and that's probably the reason for the lack of audience being able to join in. But I think we are good to go, and we're waiting to hear both Stephen now and then Dr. Vasilios. So Stephen Williams, over to you.
Thank you very much, Shruti. As I said earlier, it's a great pleasure to be with you here today. But first, I'd like to start by thanking Professor Dr. Ratan Singh for those excellent words of welcome, but all those very excellent and thoughtful words of introduction to our topic today: populism, democracy, and the rule of law in the age of COVID-19. With such an eminent starting speaker in Professor Dr. Singh, and an eminent second speaker in Dr. Vasilios Adimidis, I'm not going to give you my thoughts on populism, democracy, and the rule of law in the time of COVID-19. I'm just going to give you a few thoughts and words on the fantastic partnership that's developed since 2015 between Punjab University and Nottingham Trent University. So I joined Nottingham Trent University as the director of NTU Global back in April 2016. And in the second day in my job, the Vice Chancellor of Nottingham Trent University, Professor Edward Peck, met with me and told me, Stephen, the first university you're going to visit as the new director of NTU Global is Punjab University. And I want you to promise me that you'll visit them within a month of you starting your new position at Nottingham Trent University. And I wasn't going to disagree with the Vice Chancellor. So within a month, in May, the start of May 2016, I was on a plane over to Punjab University. So the very first international partner of Nottingham Trent University that I visited and that I met with. And I felt a very special and warm welcome there at Punjab University. I knew this was going to be a significant and important and a strategic partner for Nottingham Trent University going forward into the future. And the good news now, 5 years later, is that I was completely right in my assumption that this was going to be a highly productive partnership between the two universities, whether that be in student and faculty exchange, which we've done plenty of over the last 5 years, but also in terms of joint seminars, joint research, joint conferences, and even cultural exchange. We had the pleasure of sending our chamber choir to Punjab University a few years ago to perform both in person to the students, but also on Facebook Live to, I think, over 20,000 people of the Punjab University community. So a great, a deep and a long-standing partnership between our two universities. And one person who's been with us throughout most of that journey is Professor Shruti Bedi. So a special thanks to Shruti for both making this session happen today, but also for her kindness in hosting us whenever we've been in India, but also her visits to the UK as well to ensure that this is a deep and a strong partnership. As well as being my first university I visited as the director of NTU Global in 2016, Punjab University was also the last university I visited back in February this year, before international travel got closed down and we were no longer able to have the physical meetings that we've enjoyed over the last 5 years. So I'm delighted that today we are moving into a new era of collaboration between our universities through virtual exchange and this virtual seminar, this meeting on Zoom that we're having today. And I'm sure that we will be able to develop various virtual platforms as we go forward into the future, as our two great universities continue to develop new and innovative ways of expanding our partnership. The final thing I'd like to say is a big thank you also to the Vice Chancellor of Punjab University, Professor Raj Kumar, for all his support that he's given to the NTU Punjab University partnership since he became Vice Chancellor. He was kind enough to make Nottingham his first overseas destination for his first visit overseas as Vice Chancellor of Punjab University. And since he came into post, our relationship has gone from strength to strength. So we are delighted with that. We are delighted that we've received so many students from the University Institute for Legal Studies onto our both Nottingham and European law summer schools over the years. It's a shame that we won't be seeing those students in person this year because of the current situation, but we very much hope to re-establish the exchange of students, both physically as well as virtually, as well as faculty, once we return to some kind of new normality where we can see the movement of faculty and students once again between our universities. So congratulations again to Professor Ratan Singh and to Professor Shruti Bedi for this fantastic event that they've lined up for us today. I'll hand up back to Shruti now, but I very much look forward to hearing Vasilios give us his lecture today. And thank you very much to all the faculty and to all the students from Punjab University who've joined with us today. You're very welcome, and it's great to meet you. Thank you.
Thank you so much, Stephen Williams. It's indeed a pleasure to hear you, and your warm words have made this partnership something which is possible for the long run. And I agree that NTU was the first university that Punjab University also ventured with full force, I would say, into. And 2017 saw me delivering some lectures at the Nottingham Law School as well, which was such a pleasurable experience that I have always felt a special relationship with the Nottingham Law School, and specifically with Nottingham Trent University, the global unit, which is your team, because I have met you people more often than the others. So welcome all of you. And I would now like to request Dr. Vasilios to please deliver his talk on populism, democracy, and rule of law in the time of COVID-19.
Thank you very much, Dr. Shruti. Thank you very much for the kind invitation. And I would like to express from my part our commitment in the Nottingham Law School to work closely with you and to further extend, expand, and establish this partnership. So if I may, just a very quick preliminary note and comment on Professor Singh's very thoughtful and relevant introduction. Actually, it is very interesting how his introduction highlights the contested nature of these concepts, and especially populism, because my understanding of populism is quite different from his understanding of populism as a basis for democracy. And actually this fertilizes the debate about the essentially contested nature of this concept. But we'll discuss this a bit more after I deliver my talk. So if you allow me now to share my screen, because I have prepared some slides just to facilitate the following of this lecture. Okay, so I think you need to permit me to share my screen if it's possible. Otherwise, I can just deliver my talk.
Arpit, can you allow Dr. Vasilios to share his screen? I think the host has to.
Yes, ma'am. Now you can share his screen.
Yes, that's
I
right.
think you can share it now.
Thank you very much. Right. So I hope that the slides are visible to everybody.
Yes.
Right. So the spread of COVID-19 has put the global health and economy under immense pressure. The measures that the international community has been forced to take have caused significant changes to everyone's lives. And it seems that humanity will continue to sail in uncharted waters. Government measures have put the rule of law under pressure, and a proper balance has to be struck between, on the one hand, respect for individual liberty, and on the other hand, protection of the public interest. Democracy, populism, and the rule of law are three essentially contested concepts, and obviously, it is impossible either to offer a universal definition in today's talk or to explore their nature and correlation in depth. Yet I think it will be possible to highlight some issues which are relevant in the current circumstances. So the first part of the talk will begin with some examples of the challenges to the rule of law caused by COVID-19. Firstly, reference will be made to limitations to individual rights commonly imposed by states to contain the disease. Secondly, special consideration will take place as far as the prevention and regulation of infodemic is concerned, especially in the social media and online platforms. Finally, we will consider actions taken by some democratically elected governments, ostensibly taking advantage of this situation in order to consolidate and entrench their rule. The second part of the talk will consider how acceptable or unacceptable the measures are from the perspective of the rule of law. In order to have a solid basis for our reasoning, we need to identify the objectives served by the rule of law and the rationale behind its perception as an ideal. It will be argued that the rule of law is mainly conceived as a safeguard against arbitrariness, tempering power and its capricious exercise. In that respect, the rule of law and liberal democracy are mutually constitutive. The final part of the talk will highlight the different perspective that populism has, which makes it, in my opinion, in principle, incompatible with a firm protection of individual rights. It is almost universally acknowledged that governments faced formidable challenges in seeking to protect their populations from the threat of COVID-19. It was impossible to maintain the regular functioning of society while taking protective measures to contain the virus, such as confinement. The measures taken inevitably encroach on rights and freedoms which are integral and necessary parts of a democratic society governed by the rule of law. In emergency conditions, such as the current ones, there are certain principles which must guide state action. Firstly, the principle of legality, which provides that even in crisis, state action must be in accordance with the law. And law, in that context, includes not only acts of parliament, but other measures too, such as emergency decrees of the executive. Secondly, the principle of proportionality. This provides that measures must be proportional to the aim and of a limited duration. The main purpose of an extraordinary or a state of emergency regime is to contain the crisis and return as quickly as possible to normality. Any prolongation of the extraordinary regime has to be subject to the control of its necessity by Parliament and courts. Indefinite perpetuation of general exceptional powers of the executive to rule, for example, by decree, is impermissible. Any legislation enacted during the state of emergency should include clear time limits on the duration of these exceptional measures, a sunset clause. Thirdly, the principle of necessity requires that emergency measures must be capable of achieving their purpose with minimal alteration of normal rules and procedures of democratic decision-making. Therefore, any power of the government to issue emergency decrees should not result in a carte blanche given by the legislator to the executive. And finally, checks and balances need to be maintained as a norm. Parliaments must keep the power to control executive by verifying at reasonable intervals whether the emergency powers of the executive are still justified, or by intervening on an ad hoc basis to modify or annul the decisions of the executive. dissolution of parliaments during the state of emergency should not be acceptable. Also, it is essential that the judiciary quickly examine the most serious limitations of human rights introduced by the emergency legislation. The right to liberty and the freedoms of movement and association are maybe the areas mostly affected by the social distancing and lockdown measures. Prevention of the spread of infectious diseases is one of the grounds for which a person may be deprived of his or her liberty. However, this has to be weighed against any less stringent alternatives. The length of compulsory confinement and the way it is enforced in practice must be proportional. Pressure might also be put on the right to privacy. Access to and processing of personal data might be used in order to contain and remedy the pandemic. Many countries and companies have unveiled large-scale surveillance programs for contact tracing. Sophisticated digital technologies and tools might facilitate the epidemic surveillance, but at the same time, the intrusive potential of modern technologies must not be left unchecked and unbalanced against the need for respect for private life. Effective enjoyment of the rights to private life and freedom of conscience, thought, and religion should be utilized to counterbalance the restrictions on other rights, such as the association and movement mentioned earlier. Nevertheless, restrictions on some of these rights, such as the exercise of religious activities, might be necessary in the greater public interest. The significant restrictions to usual social activities, including access to public places of worship, public gatherings, wedding and funeral ceremonies, may inevitably lead to complaints. So regulation of such sensitive areas of activity must be strictly necessary, non-discriminatory, proportional, clearly provided by law, and in compliance with relevant constitutional and international guarantees. Freedom of expression and information, media freedom, and access to official information are of utmost importance, especially in light of the present conditions. Reliable information is conducive to the protection of public health. States have a positive obligation to inform the population about the required behaviors or measures to avoid the spread of the disease. Any restriction on access to official information must be exceptional and proportionate to the aim of protecting public health. Transparency is crucial, and public authorities shall take the necessary measures to disclose official documents to encourage informed participation by the public in matters of general interest. At the same time, official communications cannot be the only information channel about the pandemic. This could lead to censorship and suppression of legitimate concerns. The pandemic should not be used by governments as an excuse for placing prior restrictions on certain topics, closure of media outlets, or outright blocking of access to online communication platforms, silencing whistleblowers or political opponents. In that context, a malicious spreading of disinformation is evident. During a speech delivered in mid-February, the Director General of the World Health Organization observed that communities around the world were having to confront not only the spread of the novel coronavirus, but also an infodemic caused by an overabundance of information, some accurate, some not, that makes it challenging to identify trustworthy sources and reliable guidance about COVID-19. This infodemic can be seen in the spread of disinformation, misinformation, and malinformation. And I'm going to define these terms. Disinformation refers to the intentional creation and dissemination of verifiably false or misleading information, either for political or economic gain, typically by organized state or non-state actors. According to a report by the European External Action Service, coordinated disinformation campaigns have been seeking to frame vulnerable minorities as the cause of the COVID-19 pandemic and to fuel distrust in the ability of public health institutions to respond effectively to the crisis. In practice, the precise narrative promoted as part of a disinformation operation will typically vary depending on the target audience. Russian disinformation campaigns targeting domestic audiences, for example, have tended to describe the novel coronavirus as a form of foreign aggression, whereas those targeting international audiences have tended to focus on conspiracy theories about global elites weaponizing or exploiting the virus for their own ends. Although disinformation remains an important concern with respect to COVID-19, a leaked report by the European External Action concludes that the more pressing challenge for public health in this context has been misinformation, namely the unintentional spread of false or misleading information. When complex crisis situations arise, scientific experts often try to adopt a careful approach to their messaging so as to ensure accuracy and reduce misinterpretation. Paradoxically, this cautious approach may leave an information vacuum into which false or misleading information is typically ready to fill. Importantly, the spread of COVID-19 misinformation has not been without consequence. Baseless claims linking next-generation 5G mobile technology to the novel coronavirus pandemic have contributed to real-world social harms, including petrol bomb attacks on telephone poles. Lastly, malinformation refers to the intentional creation and dissemination of information that is threatening, abusive, discriminatory, harassing, or disruptive, which aims to cause harm to a person, organization, or state. In the context of the COVID-19 crisis, anti-Chinese and xenophobic sentiments have increased in many parts of the world, with a proliferation of hate speech on online platforms. An analysis conducted by Al Jazeera identified thousands of posts on Twitter employing racist terminology to describe the novel coronavirus. In light of this infodemic, states have worked together with online platforms and the media to prevent the manipulation of public opinion, as well as to give greater prominence to generally trusted sources of news and information, notably those communicated by public health authorities. Online platforms have updated their content policies in various ways. For instance, a wide range of platforms have forged partnerships with the World Health Organization and other public health institutions to promote authoritative and reliable information about COVID-19. Facebook and Instagram, for example, have been showing educational pop-ups connecting people to expert health organizations as well as local health authorities. Beyond these partnerships, online platforms have also updated their moderation rules concerning organic content. Twitter, for example, has broadened its definition of harm in order to remove content that contradicts guidance from reliable sources of global and local public health information, including tweets that encourage people not to social distance, promote harmful treatments or protection measures, or deny established scientific facts about transmission. Similarly, Facebook has confirmed that it is removing false or misleading COVID-19 content as an extension of its existing policies to remove content that could cause physical harm, whilst continuing to work with a network of fact-checking partners to reduce the distribution of posts that are false but do not directly result in physical harm. Online platforms have also updated their moderation rules concerning paid content. Facebook, for example, has temporarily banned ads and commerce listings for medical face masks, hand sanitizers, disinfecting wipes, and COVID-19 testing kits to protect against inflated prices and predatory behavior. It has also banned ads intended to create a panic or for products that claim to guarantee a cure or prevent people from contracting COVID-19. In light of this, power is exercised now by online platforms. A debate is currently taking place as to whether and how these platforms will be regulated. Online platforms interpose themselves between states and communities of people, and as fiduciaries, they should act in pursuit of the public good. Regulation of online platforms and regulation by online platforms will continue to be a topical issue even after the current state of emergency. President Trump's tweet on May 16 is indicative. The radical left is in total command, he writes, and control of Facebook, Instagram, Twitter, and Google. The administration is working to remedy this illegal situation. Stay tuned and send names and events. In this context, some democratically elected governments have ostensibly taken advantage of the pandemic to consolidate their position in power. At least 84 countries have declared a state of emergency in response to the pandemic, leading to fears about misuse of power. Reporters Without Borders has claimed that 38 countries have restricted freedom of the press as a result. Other measures include banning mass protests, postponing elections or holding them while the opposition cannot effectively campaign, selectively enforcing lockdown rules on political opponents, handing out relief payments to political supporters, or scapegoating minorities. Hungary's President Viktor Orban drove through new legislation that allows him to govern by decree with sweeping emergency powers, including the capacity to fine and even jail those deemed by his government to be flouting the COVID-19 quarantine or for spreading fake news. The opposition had demanded a 90-day sunset clause to these emergency powers in return for its support, but had its amendments voted down and therefore opposed the act. With no sunset clause, there are calls now for the European Union to enforce sanctions on one of its member states, although President Orban has announced his intention to revert to normality in early June. In Poland, the ruling Law and Justice Party were seeking to push forward with presidential elections on the 10th of May, with the previously resurgent opposition unable to put forward their case or campaign on the ground. The government also wished to unconstitutionally change the electoral rules within 6 months from the day of the vote and to organize elections by only allowing postal voting. On May 6, the Polish governing coalition announced the presidential election would be postponed, but the new date of the election has not yet been confirmed. Finally, Brazilian President Jair Bolsonaro represents another kind of unconventional response to the pandemic and has been fiercely criticized for his handling of the crisis. Having referred to the pandemic as a fantasy, he is in constant disagreement with the World Health Organization and with Brazilian health experts. It is indicative that two health ministers decided to resign in less than a month over disagreements with President Bolsonaro over lockdown measures. Brazil recorded the third highest infection rate in the world, and yesterday it had a record number of fatalities in a 24-hour period as the death toll surpassed 20,000. So how can we evaluate the legitimacy of each measure by reference to the rule of law? In doing so, we need to clarify the rationale and the objectives of this ideal. We have already referred to it as an essentially contested concept. Therefore, a universal definition is impossible. Overall, the main focus of the rule of law is on tempering power and its arbitrary exercise. Power, especially state power, in itself is not problematic and can be used to meet good ends, as has become apparent during the pandemic. So, while rule of law traditions do not seek to eliminate power, they seek to diffuse, limit, or channel it in order to be exercised for the public good. In that respect, the rule of law is not compatible with an understanding of sovereignty as absolute, acting in an unrestricted way, even if this is popular sovereignty. In the context of liberal democracy, the rule of law has to be understood as a combination of formal, procedural criteria of legality and of appropriate content of the law. On the one hand, necessary procedural safeguards have to be in place to guarantee that power is exercised fairly and predictably. In that sense, the laws must be clear, general, equal, publicly promulgated, and meet all the procedural requirements to be exercised in a predictable rather than an ad hoc manner. On the other hand, at least in a democratic society, the content of the law and the ends of the legal system, the objectives of the legal system, must be upright, so that the rule of law will not degenerate into a rule by law. This is usually accomplished by the inclusion of individual rights and liberties in the legal framework, designed to meet appropriate social and moral ends, and with an independent judiciary protecting those rights against violation by state authorities. In that sense, the rule of law and liberal democracy are complementary. Liberal democracy weighs and balances its two pillars: democratic popular sovereignty and the principles of liberalism expressed in the form of individual rights. Democratic popular sovereignty is not absolute, as the power of the people is qualified and limited by the provisions of the law. In that sense, a majority of the people or a democratically elected government are constrained by the limits set by the Constitution or other relevant national and international legislation. The relationship between democracy and the rule of law has been defined by the social contract theory, whereby individuals entrust the state with powers to pursue public goods such as security, health, and welfare, because individuals by themselves do not have the ability and resources to enjoy and share the benefits of these goods in a constant and non-exclusionary manner. Therefore, individuals enter into a fiduciary relationship with the state, such that the state's sovereign authority is linked to serving the people and delivering public goods. The exercise of public power should be subject to certain standards and rules that derive from and aim at maintaining this fiduciary relationship. Above all, the exercise of public power should not be self-interested or discriminatory, and should take a holistic view of the public good. On the contrary, measures curtailing individual and minority rights due to the popularity they enjoy with the majority, without having an obvious public good as their point of reference, such as the protection of public health in these circumstances, violate both democratic pluralism and the rule of law. It seems that populism is intrinsically connected to such measures, since its ostensible prioritization of the will of the people, quite often as the populist leader discerns this will of the people, is presented as unlimited, and the will of the people is presented as being able to overcome any constitutional or legal constraints. Populism, one more contested concept, has been defined as an ideology or strategy that pits the pure and homogeneous people against a corrupt elite or political establishment, and views politics as the expression of the general will of the sovereign people. However, the sovereign people of populism do not include the whole population, as only the group of people constructed by the populist leader qualifies as the people in populism. The popular sovereignty that populism refers to is absolute. Therefore, any constraints to the people's will envisaged by the legal framework, such as respect for individual and minority rights or an independent judiciary, have to be set aside if they conflict with the will of the people. Therefore, populism, in contrast to democracy, seems to be hostile to liberalism, and to the extent that the latter dilutes the will of the people for the preservation of individual rights and liberties. As a result, while a proper democracy limits the scope of individual rights only when it is necessary for the public good, populism, in principle, does not hesitate to curtail individual rights when this conflict with the will of the majority. The second pillar of populism, in addition to the reification of popular sovereignty, is its antagonism against ostensibly corrupt elites, which have unjustly usurped the people's power. This has led scholars to identify an overlapping mindset and similar responses to various incidents from COVID-19 to Brexit. The populist narrative of a corrupt elite which promotes their special interests and rules against the public interest is sustained by aggressive rhetoric, conspiracy theories, and often fake news directed against the establishment. Fascinating work done by Professor Ben Ansell, a political scientist at Oxford University, shows correlation between Brexit voting areas and lower levels of compliance with social distancing instructions during the pandemic. The data is, of course, open to different interpretations, especially the possibility that those in leave voting areas might be more likely to have jobs that cannot be done from home. But it is possible that a plausible interpretation is that the correlation partly reflects this overlap in mindset, just as there is an overlap in the US between Trump's core vote and those objecting to coronavirus restrictions. It should be noted that there is a very clear overlap between those who think that the coronavirus restrictions are overdone, should never have happened, or should be lifted quickly, and that the whole thing is essentially a fuss about nothing, the self-styled lockdown skeptics, and those who support Brexit think it is easy and simple and should have been done by now. It seems that there is a small but very influential group of politicians and commentators who approach a nexus of issues in the same way, be it Brexit, coronavirus, climate change, immigration, or any number of other things. So to conclude, how can we distinguish between legitimate and arbitrary limitations to individual rights and consequently pressures on the rule of law? In my opinion, we need to go back to the roots of the rule of law philosophy. The main distinction that was drawn 25 centuries ago in the writings of Plato and Aristotle is still relevant today. This is the distinction between true, legitimate forms of government, that is, governments and leaders who are concerned with the common interest and the public good, and those governments that regard only the interest of the rulers or of their supporters. For Aristotle, the latter are defective and perverted forms of government. They are despotic, whereas a state should be a community of free people. And these free people have entered into a social contract with the state, accepting necessary and proportional limitations to their individual liberty, if this is in their and their community's best interests. Anything else would be incompatible with the rule of law. Thank you very much for listening.
Thank you so much, Dr. Vasilios. Brilliant, and what I'm amazed at is that you could pull all this together in half an hour, because I was wondering when we had discussed this topic and you were saying that I would like to speak on it. I was just thinking that how are you going to manage to get this all together in one go in 30 minutes? But thank you for such a brilliant exposition, and so glad to have been a part of this and have heard you. There are so many thoughts, and it's given me food for thought. So I'm sure the participants in the audience have enjoyed it thoroughly as well. This is something that I think we can do again when the connectivity issues are better, and so it's just a beginning of a longer relationship between the two universities and the two law schools.
Brilliant to hear that. Thank you.
Thank you so much. And of course, for any person dealing with constitutional law, rule of law, democracy are things which are embedded in their hearts. And like you say, that it is the free people who it is the people who have given this power to the state through a social contract, which you're speaking about at the end, which is the bedrock of any democracy, which needs to be sustained, be it any kind of condition in the world, be it a COVID-19 health crisis or something else. So thank you so much once again. I would now request Mr. Chris Cabot, the college international manager, who has been closely associated with Punjab University, a few institutes specifically with the business school, with the law school, and the human rights school, to share his thoughts and few words with us on this occasion. Arpit, if you could unmute Mr. Cabot. Yes,
yeah, thank you very much, Shruti. I think I would like to thank the whole team to have put this wonderful lecture together today. And I think to put a bit of a positive spin on this COVID-19 crisis, I think this is a great example of how constraints, could lead to very positive things. So, the arrangements we have with Punjab University, we're very proud of these arrangements at NTU, and we'd like really to nurture those wonderful relationships for the future. So I think my wise words would be around, try and, bank on these new ways of communication that, we've all been using in those recent weeks to really push our collaborations forward with new innovative ideas for our two law schools to share ideas and maybe collaborate on exciting projects. So again, thank you very much for all of you, and hopefully we'll be arranging these new opportunities very shortly. Thank you.
Thank you so much, Mr. Cabot. And it's, as I say, that it's a great pleasure to have the entire team here with us of NTU Global. And now I would like to come to Ms. Vidhi Sahai, who is the lady behind all this happening to. And I would really like to express my gratitude to her. Not only has she been a friend, but she has been the impetus for this entire relationship between NTU and Punjab University. When I came to NTU in 2017, she was the first person who I saw at the train station in Nottingham. So we go some time back, and I think that moment really hit off with both of us, and we have carried forward this relationship together. Vidhi, I would like to ask you to share your thoughts as well.
Thanks, Shruti, for those very, very kind words. I think the partnership between Punjab University and NTU is a special and strategic partnership, which, I've been lucky enough to have Mr. Stephen Williams, Chris Crebo, Dr. Vasilios, their support to, engage very meaningfully with Punjab University, and of course your support and guidance, and the guidance of Professor Ratan Singh. It's lovely to see UILS students in NTU every summer. I've gotten to know a few of them. I believe some of them are now interested in applying for our master's programs, our LLMs, which is wonderful. So thanks again. We look forward to welcoming UILS students to NTU and sending NTU students to Punjab University when as and when the situation normalizes. So thanks again, Shruti, for everything you've done, and to make this partnership, as Stephen said, go from strength to strength.
Thank you so much, Vidhi.
Yeah.
There is one question by Mr. Rangat Ghira. Dr. Vasilios, if you don't mind, should I read it out to you so that maybe you can...
I have access to it. Thank you very much. Okay. It is about the GDPR as a model for data protection law for many countries, and how will the GDPR affect and be affected by the increasing privacy issues in various apps as mandated by the governments. I am not an expert on the GDPR or data protection law, but my perception is that since such measures and regulations will continue to be topical even after the pandemic, and with the need on the greater public interest to continue tracing contacts and protect the wider public from the spread of the disease, I think that there will need to be a relaxation in some strict rules on the GDPR and on other individual rights. Having said that, the current legal framework already provides for instances where such relaxations need to take place, or curtailment of some protections need to take place. So there's no need to introduce new measures. And I think this is quite alarming when it is done, because the current measures provide for exceptions, provide for such actions taken in the public interest, for the curtailment of individual rights and data protection rules for the public interest or in the public interest. We can see that in terrorism, for example. So now public health might be another legitimate aim, which makes it necessary to reconsider the extent and the scope of the GDPR, among other measures.
Thank you, Dr. Vasilios. That's brilliant, I think. I would like to request Professor Ratan to thank our guests.
Yeah, thank you, Dr. Shruti. In fact, before I go with this formal vote of thanks, because as the professor Adam Lees was talking over populism, and we all agree with this because populism is people-centric. And once this is people-centric, and certainly we do talk about many liberties, many rights, and somebody to maintain a balance, because the rights are curtailed, the rights are violated. Maybe this during the period of these 2.5 months, because reason being the government is to execute its own policies. So sometime so there is a conflict in between the rights and the violation of the rights, and now how many rights are to be violated, up to what extent these rights are to be violated, and for which interest these are to be violated. Maybe for the interest of the people, for the interest of the general public, these may be violated. And as we said, there must be proportionality of the rights and the violations. What I have observed from the news with reference to Asian countries like in Bangladesh, like in India, like in Pakistan, and some other countries also, that who's to decide about the proportionality? There is another organ who's to decide, maybe judiciary. So being a student of Constitution, I say, I won't name exactly, and I think they have not maintained proportionality. Otherwise, they should have come forward to protect and to make the proportionality and to give the directions to one wing and to another wing. So what I feel is that in the countries like where the democracy like of India, the institution which should have come forward to make the proportionality, probably they have not done their work. So this is just my footnote into the talk of Professor. So I, on behalf of my University Institute of Legal Studies and my faculty members, I thanks to all the panelists, all the speakers, and the whole team of NTU, because reason being the relation which we have developed in just very few years, probably, but I feel this will continue. And when our students visit there, and even Professor Shruti, she has visited your university and she speaks very high. And I'm very sure that whenever we will have the admission of our student in the post-graduation in your university, they will definitely get much of, and definitely they will enjoy their studies for the further research in your university. So thank you very much for sparing your time and interacting with our student, with our faculty, and thank you very much, please. God bless you, and thank you very much.
Thank you so much, everyone. It's great to have had this been put together. And I think it's time to sign off. So thank you, everyone, for being here. Thank you.
Thank you. Thank you very much.
Thank you, Shruti. Thank you, Professor Singh.
Thank you. Thank you. Thank you. Bye-bye.
Bye-bye.
Bye. Bye.
Bye.